We're back today with Lori Vallow. She has a pretrial hearing, or she had a pretrial hearing that happened on May 29th. And we were streaming live that day because Lori Vallow had a hearing where she was trying to get Judge Boreski, yes, the patient Judge Boreski, removed from her trial that she has upcoming. And then she also wanted to have him removed from other cases that are assigned to him as well. Now, spoiler alert, that didn't happen. And probably not a spoiler alert for you guys because you guys were watching it with me. But Judge Boreski is still going to be the judge on her case. And honestly, I feel like Judge Boreski probably wouldn't mind not being the judge on her case, but it wouldn't be a good look for him because obviously, you can't just remove a judge just because, they're not getting along or they hate each other. It will be because, if the judge showed any bias or prejudice against Lori Vallow, and if Lori Vallow had actual concerns that were real, that would, make another judge remove Judge Boreski from this case. So Judge Boreski is here, and you can just feel it. It's so tangible that he's just he's just tired. He's like, okay, all right, well, you're confusing these issues. Okay, tell me, what do you want to do? Okay, so if you don't want to attend, then don't attend. Talking to her is like talking to a fucking toddler who just doesn't understand. And, I understand that it's hard to understand what's going on because, she's in a courtroom. She's trying to represent herself. She doesn't know what the fuck she's doing. And she's around people that are smarter than her. But I don't think that's something that she wants to accept and really... I don't know. Lori Vallow is the type of person who's like, I don't care. I'm smart. I know everything, And so it's really hard to see her trying to understand what's going on in the courtroom. Everyone's trying to be really patient to explain to her. And even Judge Boreski at some point, when he's trying to explain something to her and she's not fucking understanding, he's like, okay, State, do you want to explain to her? And then Trina K tries to explain it. She ain't still understanding. So it's kind of rough, Now, we're going to be watching this hearing, and Lori gets heated, as always, because Lori... I'm telling you, you have to watch out for people like Lori, like fucking Sarah Boone. These are people that are overly really nice and maybe a little bit too nice, super friendly, very chipper and stuff like that. But man, the moment they realize they're not getting their way, they'll fucking turn their backs on you, okay? They'll get all heated, they get all sassy on you. You gotta be careful. Because I think Lori Vallow always tried to pride herself in being the person that was she's so my God, she's such a likable person. She's so friendly. Look at how she was with law enforcement. Look at how she was in the interviews. I think she wants to be a very likable person. However, when she doesn't get her fucking way, her true self really seeps through and she gets frustrated. She raises her voice. We don't really hear the baby whiny voice anymore. We start hearing the real voice. Okay, maybe not that much of a difference, but yeah, she does act like a petulant child. So right now we are in the midst of jury selection for Lori Vallow's attempted murder trial, which is supposed to happen on Monday or maybe Tuesday. I think leaning more towards Monday. However, during jury selection, apparently Lori Vallow said she wasn't feeling well during the afternoon, so they had to stop doing jury selection. And the judge essentially was like, okay, bitch, you got to quarantine because you ain't getting us sick. You got to make sure no one else is going to get sick, and we ain't having none of that. Okay, he didn't say it like that, but here's what he said.
All right, will you please, I know you...
Why can't I hear it?
...have restrictions on what you're able to do, but if you have issues...
Wait, you guys can hear it. Hold on a second. Why can't I hear the fucking audio? Give me a second. Did I restart my computer? Because sometimes when I restart my computer, shit goes to hell.
Where I know in the jail people get...
Give me a second. Headphones?
...quarantined or something.
Okay, I'm going to replay that. I'm so sorry. Because I couldn't hear shit for some reason.
All right, will you please... I know you have restrictions on what you're able to do, but if you have issues where I know in the jail people get quarantined or something, if you don't think you're going to make it to court on Monday, please let your team know sooner rather than later, okay? All right, we'll be at recess. So
she wasn't feeling well, and they had to stop doing the jury selection. So I'm assuming maybe everything on Monday gets pushed a little bit. Now, we'll see. We'll see if she ends up feeling better and shows up on Monday. Hopefully it'll be fine and there's no more delays and all that stuff. Because, a lot of you guys are like, when are we going to be done with Lori? I'm like, soon. We haven't really heard too much from Lori, but ever since she's been representing herself, it's been Lori. And we're Lori's entertaining and all, but we got to move on. All right. We got to move on. So hopefully, she won't be sick and we'll just hurry up and, do the trial, and then we won't have to hear from her for a while, All right, so we are going to hear from her today, though. So she does get very heated and frustrated. Judge is trying really hard to be patient with her, but you know, it's hard to be patient with someone who's like Lori. It's hard, where you're basically reiterating and repeating things over and over again, and she's just not understanding it, or maybe she doesn't want to understand it, or maybe she's just arguing for the sake of arguing. Like I don't know. Lori is she's kind of like, I would say she's like definitely one of those like S tier people that you don't want to run into when you're in the customer service industry, because they will give you a fucking headache. Okay, they'll pretend to be nice and on your side, and they'll smile, and then they'll just slowly turn on you, really, either slowly or like really quickly. So Lori Vallow pretrial hearing, and again, it's for the attempted murder of Brandon Boudreaux, who was the guy that was dating her niece at the time, or sorry, I think they were married. Yeah, they were married, and they are no longer married, and he's still alive. So he's still alive and well. And apparently the state believes that Lori Vallow was in cahoots with who else? Her brother, Alex Cox, in trying to murder Brandon Boudreaux. Now, they were successful in murdering Charles Vallow, so maybe they're getting really cocky. And I think the attempted murder of Brandon Boudreaux was after the children, right? And after Tammy Daybell. Like, these people were just so cocky. They were just willing to wipe out anyone that they thought was in their way. Pretty fucking crazy. Hey, Mari, how are you doing today? Hello, Taxi, Aaron, Diane. I was talking to my Twitch chat earlier about this gnarly pimple that I have on my damn face. Oh my God, it's so horrible. I've never had a fucking pimple this big. Right now, this is not the actual pimple though. There's a pimple band-aid on top of it, but it's the size of a quarter. It hurts so much, and it actually changed my face shape. If you guys look from far away, I kind of have like a square shape right now, which kind of looks cool. But yeah, it like changed my face shape because of how swollen this side is. Hey, Nicole, hello, happy Saturday. Mari says, upset she lost all her emotions is draining to be snarky. Yeah, she's like, you haven't granted any of my emotions. And the judge is like, well, I just granted your motion like a couple seconds ago. She's like, okay, well, except for that one. You know, she's like the type of person who will change the fucking goalpost. You can't reason with her. You can't. Take a needle to it. Okay, so what happened was I put the pimple band-aid on there, and when I took it off, it kind of ripped the top layer, and then it was nasty. Okay, so now I'm like, fuck, because I know you're not really supposed to pop your pimple, but it happened inadvertently. But now I feel like I'm gonna get a fucking scar on my face because the crater is pretty fucking huge. It's like a giant ass fucking crater on my face right now. And I'm like, I don't know what to do. It's just, this is horrible. You haven't watched any coverage, knowing Corgi would cover it. Yeah, if you guys want to deal with headache people, I'm the one who will be here holding your fucking hand. I know what it's like to deal with people that are a fucking headache, okay, in a shit show. You gotta drain it. It's been drained, and it was very fucking painful. But now it's like a crater, and I think like the stuff inside is starting to build up again, and I'm like, oh my God, like how do I deal with this without getting a fucking scar? Or do I just get the fucking scar? Because I was thinking about doing this like laser shit, although I don't like doing stuff to my face because I'm fucking scared. I don't like needles. I don't like pain. Even when I was doing the micro needling for my fucking eyebrows, oh God, I hated that shit. And they give you numbing medication, but I don't like pain at all. But I was considering doing the laser shit, you know, to get rid of like some of the scars that I have. And I'm like, oh, do I really want to do it? I don't know. I'll let you guys know. I'll let you guys know if this turns into a giant fucking scar. But look at that. Shit's fucking, it's gnarly. And then I was grossing out my chat by telling them about that one scene. If you guys ever watch Osmosis Jones, there's that one scene where his pimple pops and it pops on the school teacher. And it's so fucking nasty. Okay, I'm going to start grossing you guys out. I don't know. Maybe you guys will be even more grossed out because we're about to get into Lori Vallow territory. All right, y'all. So, May 29th pretrial hearing. We did not cover this, but we did cover a different hearing where she wanted to have Judge Boreski removed. That motion was denied by a different judge. And here we are today in front of Judge Boreski. I think this might have happened a couple hours after her motion was denied. So it's like you try to have this judge removed, and now hours later, you are facing this exact same judge that you try to have removed. Kind of awkward, a little bit awkward. Esthetician, I'll consider that. I don't know. There's a lot of really sketchy ones in the area. I wish I had one that was like recommended and trust or something like that. Maybe I could ask my friends, but I don't think any of my friends do any of that like stuff. I don't know. I feel you. People's gonna be stressful. Yeah, I've just never had anything this big before. It's ginormous. It's so painful. Like the lower quadrant of my face just like fucking hurts. I was like, should I take Advil? I don't know. Is that being too extra? I don't know. You have a high pain tolerance and only one tattoo. Oh my gosh. This girl has a tattoo on her armpit. And I was like, ah! I don't know. Like, I don't like pain, and I also don't like being tickled. Oof. I'm bad with pain, but I have 7 tattoos. See, I think that's what's making me not get tattoos, because I don't like pain. I don't like pain. I don't like sitting there. I don't know. Oh, gosh. But yeah, no, there's this girl had like, no, it looked really cool, though. Like, cool, intricate fucking tattoo on the armpit. And I was like, I forgot where I saw. I think I saw it on Instagram. And I was like, oh my fucking God. Like, I'm just having so much. There's just so many things going through my body right now. Like, I'm ticklish. It looks painful. It looks, like, I don't know. Just like feeling everything all at once. All right, guys. Let's do this. Oh, stop swearing. Fuck, I should stop swearing. Damn, fucking shit. I really, you're right. I should totally stop. You're definitely right. Definitely. All right, guys, let's jump into this. So, Lori Vallow pretrial hearing, and thank you so much for listening to my preamble about pimples and shit like that. But here we go.
And so, but it hasn't been dropped to them yet because it's after the indictment. So it needs to have probable cause hearing, which is the 13.5 hearing. So we need to have a probable cause hearing so that we can add that to the guilt phase, and that's something that gets taken to the jury after probable cause has been found for these aggravators that are alleged.
I think you're referring to the rules for capital cases when there's aggravators filed in death penalty cases.
Correct.
You're entitled to.
I got you. I yeeted them. Maybe they just wanted to argue and stuff like that. So I got you. Tattoos are like rug burns to me. I wish I could say that. I don't know. I'm too scared. Too scared. Okay, so they're talking about aggravators. Lori Vallow wants to basically... Do you guys remember in the trial, at the very end, before she was found guilty, they talked about the aggravators. And so essentially, in the charges, there could be aggravators, which will possibly enhance the sentencing even more. Now, because she wanted to wait until this trial before she was sentenced, I think they're going to do sentencing all at the same time, which to Lori probably doesn't really matter anyways, because she's already serving a life sentence in Idaho. So that's why all this is probably just fodder for her. But basically, there are aggravators that the state might add to this case, giving her more of like a severe sentencing. But like I said, kind of doesn't really matter because she's already serving a life sentence. But it should matter in terms of like, well, what happens if, if the murder, conviction gets overturned? I don't know. Like, you never know what happens, right? Probably not. But in, some scenario, what if something happens to it? We just want to make sure that we don't loosen up or like are lenient on other charges, just assuming that she's already going to serve a life sentence. Because you never know. Maybe shit happens.
A probable cause hearing, depending on the aggravator. This is not a capital case.
I know it's not a capital case, and in normal capital cases, you don't have an aggravation phase either, right? Only in a capital case.
Actually, you have a guilt phase, and then you have a mitigation aggravation phase.
Actually, you have a guilt phase, an aggravation phase, and a penalty phase.
Right.
If the aggravators aren't found as a completely separate independent hearing, then there's no penalty phase.
So with this,
I love how Kay just casually just chimes in. Well, actually, it's actually X, Y, and Z. And there you go. You don't know anything, and I know it all. Just kidding. I like Kay. I like Trina Kay. I know some of you guys thought she had too much of a C-word energy, but I like her. I like people that are like sharp like her. I like sharp, sort of aggressive, and just, I don't know. I get like the no-nonsense bullshit from her. I like it.
statute for this charge only being the one statute, what are you getting out of the aggravation phase? I don't understand.
Well, first of all, the jury in the initial phase doesn't.
My microphone? Oh, is it low? Hello? No, my microphone is very loud. If I make it any louder, I think you guys will probably yell at me because I'm blasting your ears. I can turn down this audio, I guess, because maybe my voice in comparison to the video is very low, maybe? But it looks like it's almost the same. Hold on, let me see how loud this video is.
Doesn't determine whether or not it's a dangerous felony, which they need to find.
Oh, do you want me to turn up this video? Maybe I should turn up this video for you guys. Hold on. Because it seems like my voice is definitely a lot louder than the YouTube video. Sorry, I had it in reverse because for some reason I thought the YouTube video was really loud. Give me a second. Let's see, where's this playing on?
And then the aggravators, I think the state has a right to.
Let's see. Hey, Mama Bear, how are you doing today? How's it going? Hello, hello. Well, I will say this though, I'm not the only content creator that people once in a while complain about the cursing stuff. I know I think Emily Baker, you know, because a lot of people that watch her probably don't expect Emily Baker to cuss a lot, but Emily Baker even has it in her intro where it's like, I like cursey words. I don't care what you think. I'm gonna keep cursing. So I think it's always interesting when people expect to have a filter on other people. All right. Although I will say though, I have, you know, curse a lot less. I used to curse a lot more when I was younger. I try to be more mindful, but it does come out of my mouth sometimes. Okay, so, audio. Let me know how the audio is. How you guys, I can boost it up a little bit.
Attempt to prove those to.
Yeah, I will. Let me boost up this audio for you guys. Volume booster. Let's do volume master 190. Okay. She had to censor her intro? What do you mean she had to censor her intro?
To the jury to offset any mitigation.
Nope, that's too loud. Nope, we ain't doing that. Let's do. Sorry, guys. Okay, I'm gonna slightly booster it. All right, I'm gonna rewind it a little bit though. Sorry. Actually, can we just start over? Let's just start over. Short stream today, guys. Short stream today.
And so, but it hasn't been dropped to them yet because it's after the indictment. So it needs to have probable cause hearing.
Oh, you know what? The issue is Lori is really fucking loud compared to the judge. Yeah, you know what? I'm gonna make it back to the default audio because Lori's so loud. Lori, why are you so loud? Yeah, she's really loud. I don't know why she's always, I don't know, choking on her microphone. Like, chill. I'll do my best to try to adjust the audio between Lori and the judge, but because I'm taking notes, I might not be able to do it as well. So just a warning to you guys, if there's ever a pause and you think Lori Vallow is about to talk, it might be a little bit loud to you guys because she's a lot more louder than the judge. Oh, really? She used to say fuckery and then it beeped out. It changed into her. Wait, really? Oh, I actually didn't notice that. Oh, maybe. I mean, maybe the sponsors were like, hey, you think you can chill a little bit? Possibly. Okay, I'm going to start over. And again, Lori's going to be loud.
And so, but it hasn't been dropped to them yet because it's after the indictment. So it needs to have probable cause hearing, which is the 13.5 hearing. So we need to have a probable cause hearing so that we can add that to the guilt phase, and that's something that gets taken to the jury after probable cause has been found for these aggravators that are alleged.
I think you're referring to the rules for capital cases when there's aggravators filed in death penalty cases.
Correct.
You're entitled to.
So again, this one is not a capital case. Her previous murder trial was supposed to be a capital case, but the state of Idaho fucked up and essentially did not turn in some discovery within a certain time period. So they dropped the death penalty for Lori Vallow. This one and the previous one, these are not capital cases. She's not facing the death penalty.
A probable cause hearing, depending on the aggravator. This is not a capital case.
I know it's not a capital case, and in normal capital cases, you don't have an aggravation phase either, right? Only in a capital case.
Actually, you have a guilt phase, and then you have a mitigation aggravation phase.
Actually, have a guilt phase, an aggravation phase, and a penalty phase.
Right.
If the aggravators aren't found as a completely separate independent hearing, then there's no penalty phase.
So with the statute for this charge only being the one statute, what are you getting out of the aggravation phase? I don't understand.
Well, first of all, the jury in the initial phase doesn't determine whether or not it's a dangerous felony, which they need to find. And then the aggravators, I think the state has a right to attempt to prove those to the jury, to offset any mitigation or to be weighed against mitigation at your sentencing.
And isn't that normally put together with the guilt phase? Like they would have that on the back page where it says the aggravators and the guilt?
No.
So are we going to have a whole nother aggravator phase in this case?
If the jury finds you guilty of the charge, and the state wants to proceed with aggravators, yes.
And so we do not have to have a hearing to determine if there's probable cause for these aggravators?
No,
They're just alleged aggravators.
correct,
And the grand jury never found probable cause for them.
correct.
So you're saying that if the guilt phase goes through and they find you guilty, then you have an aggravator phase added to that?
That's what I said.
I did watch this about a day or two ago. I remember the judge saying that the aggravators, like one of them was like using a maybe like deadly weapon or something. The other one was causing harm to someone or potentially almost causing harm if it like inflicted emotional harm on them and something like that. I mean, the judge will say it soon, but I kind of wish it was said in the very beginning.
Okay.
Lori
on
gives
one
up. Oh no, not the Chad. Hi Rain, how are you doing today? Hello. I know, Sister Sherry. Oh, it is. Yeah, that is very true. YouTube doesn't like it if you drop the curse bombs in the beginning of the stream, and I think videos as well. Hey, Vasenya, how are you doing today? Hello. How's it going? I slept under the table those nights. Ooh, it was a couple nights I wake up seeing a doll turn his head towards me. Wait, is your wife just fucking with you or something? Like what? Oh, is this when you were a kid? Oh man, when I was a kid, we had a 4th grade sleepover and we watched the movie Dolls. Okay, we all went to Blockbuster. A bunch of little girls went to choose this movie Dolls, and it was the most scariest, goriest, fucking horrible movie ever. But I loved it. It was amazing. I don't know why we chose that movie. Maybe we thought it was gonna be something like cute or something like that, but it was so fucking scary. You guys ever seen Dolls before? Oh my god, it's gory. Loved it.
The allegation of aggravating,
Okay.
it was on my desk.
Your Honor, I would just like it to be on the record clear that the Rule 13.5 that I'm talking about is about non-capital cases.
Okay, and that's what he said.
I know in capital cases, they call it a Cronus hearing, but this is for non-capital case.
How's the audio, by the way? Is it okay for you guys? Okay, so Rule 13.5. Did she say B? Arizona Rule Criminal Procedure allows for amendments to charging documents in non-capital cases to address formal defects or omissions such as miswriting or improper English. Charging document is automatically amended to conform to the evidence presented. Oh, you know what the judge is going to bring up later on in the hearing? He's going to talk about amending charges, such as like if you were initially going to charge someone for like second-degree murder, then you change to like first-degree murder. That's when it would apply. So I don't know. Here's the thing. I don't know if the person that's whispering into Lori's ear, the advisory counsel, I don't know if he's whispering something totally different and then maybe she's not understanding it and then it comes out to her mouth as like what's not being heard in her ear. Or if, I don't know, maybe there is some mix up or maybe he's not giving good advice or something like that. Because that would kind of suck if you're whispering to Lori's ear and you're like giving her advice and then she completely doesn't understand it and completely misinterprets it and says something totally different. Because he's like, oh my God, this could make me look bad. That's not what I said, Lori. Lori!
Well, it says under 13.5A, a defendant may challenge the legal sufficiency of the state's allegations by filing a motion under Rule 16.
A. Prior convictions and other non-capital sentencing allegations, challenges. Within the time limits of Rule 16(1)(b), the state may amend an indictment, information, or complaint to add allegations of one or more prior convictions or other non-capital sentencing allegations that must be found by a jury. A defendant may challenge the legal sufficiency of the state's allegations by filing a motion under Rule 16(c). And then B was what I read earlier about altering charges.
Is that what you're talking about?
Correct.
It doesn't say you get a probable cause hearing regarding the aggravators.
Well, I'm challenging the state's allegation of aggravators by asking for a 13.5 hearing on it.
Because I guess I don't really understand, because this is talking about the original charges, not the aggravators. Like her original charges, attempted murder, and I don't know if there's any other charges that are listed under that.
So the state's aggravators that they've alleged is that the
Oh, here it
offense
is.
involved the infliction or threatened infliction of serious physical injury.
Physical injury.
The offense involved the use, threatened use, or possession of a deadly weapon or dangerous instrument during the commission of the crime, specifically a gun.
Yep, the gun.
The offense involved the presence of an accomplice. The offense caused physical, emotional, or
Deadly weapon of instrument of a crime. And then he said accomplice, which check, that is the brother. And then what's the one that he's saying right now? Cause emotional, physical, right, harm to either the person that was the victim, or if the victim ended up dying, then to the family members.
financial harm to the victim, or if the victim died as a result of the conduct of the defendant caused emotional or financial harm to the victim's family. The next one is the defendant was previously convicted of a felony within the 10 years immediately preceding the date of the offense. This one's really not very specific. Any other factor that is relevant to the defendant's character or background. So if you were found guilty by a jury of conspiracy to commit first-degree murder, which of these aggravators do you think there's not legal sufficiency for a jury to determine? Because they seem pretty inherent in the charge itself, except for your prior convictions, which, are you saying you don't have the prior convictions within 10 years?
No, I'm not saying that. Which of them don't qualify for the jury to make that determination?
This is crazy. He always does this. He will ask very pointed questions to Lori, and she'll either not respond and she'll just give like a winding answer, or look at what she does here. She answers the question with a fucking question. You're not answering the question. It's like, okay, you could just say you don't know the answer to it. I don't know. Confer with your consulting advisory counsel.
No, you're asking for me to make a determination that there's a legal sufficiency for them to go to the jury.
Correct.
So I'm asking you, if you were found guilty by a jury of the charged offense, which of those aggravators that have been alleged by the state do you think there would not be legal sufficiency for? Because as I look at those aggravators, most of them are inherent in what you're being found guilty of. Again, if the jury found you guilty. For example, the first aggravator, it involved the infliction or threatened infliction of serious physical injury. The allegation is someone shot at the victim. That's the threatened infliction of serious physical injury. So it seems like that allegation, there's sufficient evidence for a jury to decide whether that's an aggravator. The next one,
Accomplice.
the offense involved the
Oh, the
use,
weapon.
threatened use, or possession of a deadly weapon or dangerous instrument during the commission of a crime. Again, if you were found guilty of the charge, as the state has alleged, the jury would find that a gun was used. So that's a separate aggravator, again, that would already be determined by the evidence.
Again, so he asks her a question. She doesn't know the answer to it. And he's going through each one and breaking it down for her. Now, I don't know if maybe Lori, maybe she's the type of person who doesn't really listen to people when they talk. Maybe she's the type of person who just like listens to argue, not really to listen to listen. You know, there's some people like that that like won't really listen to you or what you're saying, but they're like ready to fight back and just argue with you. Because he's going through each one, through all the aggravators, and he's like, oh, yeah, you know, it seems like the aggravators are kind of inherent in what you're being charged with. You know, for example, like, you know, Brennan Boudreaux, you know, possibly, you know, having a injury inflicted on him, or like, you know, a weapon being used on him. Or the next one's gonna be like the accomplice, right? Like, ooh, you had your brother, you know, possibly do this. So I don't remember what she replies with, but it's probably with a non-answer. We'll see.
The state has alleged an accomplice, your brother. If the jury were to find you guilty as charged, again, my understanding of the state's allegation is your brother attempted to shoot Mr. Boudreaux. You weren't in Arizona. So if the jury found you guilty of this charge, it would mean they found you guilty as an accomplice. If someone shot at the next aggravator, I don't think it's a leap for a jury to presume there's some sort of emotional harm. So I'm struggling with what legal sufficiency you think is lacking for a jury to make those determinations. Again, only if the jury found you guilty of the charge that you're charged with.
I understand, Your Honor, but in 13.5, right, whether capital or non-capital, the state has the burden to establish probable cause, the legal sufficiency of an amended indictment. This is an amendment. This didn't go to the grand jury. Is that correct?
Right.
So now I have the right to ask for a hearing so that probable cause can be found for these aggravators ahead of time.
So you're confusing two things.
Okay?
All right. 13.5B talks about amending the charge or the indictment. Okay, your charge is conspiracy to commit first-degree murder. It's not, your charge is not being amended. The grand jury did find probable cause for that charge.
Correct.
An aggravator is not an amendment to the indictment.
It's a whole nother allegation. It's a whole separate allegation.
Difference between an aggravator and changing the charge that you're charged with. If the state were to change the charge that you're charged with, for example, if they changed it from conspiracy to commit first-degree murder to conspiracy to commit second-degree murder, there'd probably need to be a new probable cause finding.
Correct.
Secondly, as to the allegation that it's a dangerous offense, the grand jury did make that finding because that allegation was included in the indictment that it was a dangerous offense. So there has been probable cause as to the dangerous factor.
Okay, if that is the case, then why isn't that found in the original guilt phase as opposed to having a whole nother aggravation phase after that, as if it's a capital offense? Because there's one statute,
Well,
there's one sentence, there's no arguing the sentence, and if it's already a dangerous crime, then there's no reason to have an aggravator phase.
What do you mean there's no arguing and there's one sentence? I don't understand what you're saying.
There's one sentence for the charge. There's only one sentence for.
I feel like they're speaking like this. It's like there's no matches. You know, it's just like a completely mismatch of a conversation. But I think it could also be incredibly hard for the judge to explain to someone that doesn't really have experience, because it's like, well, maybe we have to go back to like law school basics or something like that, you know, for you to really understand. I'm sure her advisory council probably has a headache with her too, trying to explain everything. It's like, dude, just fucking hire, just have an attorney represent you, you know, public defender, just get someone to represent you. Don't try to do this yourself. Why? We get it. You want to have a challenge, your borders your life, but come on. You're not doing yourself a service.
For this charge. The charge. There's only one sentence for this charge. And if it's already classified as a dangerous charge, is what you're telling me, right? Because it's conspiracy to commit first-degree murder, that's a dangerous charge. The jury has already found that it's a dangerous charge. Then what is the aggravator phase finding? If it's already a dangerous charge and there's only one sentence.
Oh, I want to correct myself, by the way. I think earlier I said attempted murder because I was thinking from the perspective of Alex Cox. But since this is Lori that's being charged, it should be conspiracy to commit first degree murder. Right? Is first degree?
Does the state want to respond why the state wants to proceed with aggravators?
The judge is like, okay, I did my best to explain it to you. All right, someone else, step it up. I can understand what the judge is saying, but when Lori starts talking, I do get a little bit confused because I feel like it's just like a jumble of like words.
What is the aggravator phase finding?
Hi, Diane. Hi, Moondog. How are you doing today? Patience of a saint. Yeah. You know, the thing with the other judge in the Sarah Boone case, Judge Kranick, I believe Judge Kranick was also a professor as well that was like teaching law students. So when you're teaching students, you have to find really crafty, easy ways in order to get things that are very complex and kind of put in a way that makes it easy for people to understand, in more simpler terms. So he has like the teaching experience. He's got the background to do that. I'm not really quite sure about this judge. I don't know if he does like any like teaching roles or anything like that, but if he typically doesn't, it might be a little bit harder to kind of like dumb down law to someone that doesn't really understand. So, but I'm sure he's getting a lot of experience doing this because I'm sure there's a lot of people that might want to represent themselves. And sometimes you got to be really patient and, you got to find more craftier ways to explain things in a way that would make normal people understand. But, I actually looked up this judge. The Google autofill thing is so funny. I think the first search result that pops up is Judge Boreski wife. And then I screenshotted the search thing in the, in the Discord. It was like Judge Boreski wife. Oh, Judge Boreski, age. Is Judge Justin Boreski married? I'm like, people are trying to thirst over him. This judge. Anyways, so I thought it was funny. All right, so judge is giving up, and he's like, hey, Ms. K, do you want to take over?
If it's already a dangerous charge and there's only one sentence.
Oh, sorry, I was going to mention, so I looked into this judge. Apparently, he was a criminal defense attorney. Interesting background. Pretty cool. He was like a criminal defense attorney. Oh, I think that was like more than over like 10 years ago or something like that.
Does the state want to respond why the state wants to proceed with aggravators?
To start with, the jury is not going to make a finding of dangerousness as part of the guilt phase per case law. That's not permitted. So the jury has to make a separate independent finding after they find the defendant guilty. The dangerous finding will include the use of a weapon and or the intentional infliction of or threatened infliction of physical injury. So at the very least, the jury has to make a finding as to dangerousness.
I agree about dangerousness. I guess the question is, why does the state want to prove up aggravators if the jury finds the defendant guilty of the charge as a dangerous offense, given the sentence?
Your Honor, in all honesty, you could ask me this, 10 years ago before Blakely was put out. As case law changes on appeals, I've had to come back before and redo a penalty phase, an aggravation phase, and re-impanel a jury. So I prefer to, since we're already going to have an aggravation phase for the dangerous allegation, to add on the other factors, and therefore I don't have to ever worry about this coming back on appeal later.
All right.
How is it not already found?
I don't want to come back and deal with this bitch, okay? Let's just get it done right now.
This coming back on appeal later.
All right.
Without the
How is
B-word.
it not already found to be dangerous? You just said that if they find me guilty, then it will be dangerous.
I didn't say that. I said if they find you guilty, then they make a determination whether or not it's dangerous. Now, I think what I meant was when a crime involving a weapon is used, whether it's a gun, usually it's sort of a foregone conclusion that if the jury found you guilty of conspiracy to commit first-degree murder by someone shooting at another individual, that they're 99.9% likely to find that it was a dangerous offense. But it's something the jury has to do.
Right, but usually aren't aggravators for sentencing? What other purpose does it serve in this case with this charge with one statute? You can't give me less time, you can't give me more time, you can't do anything else except for, it's one statute.
I guess the prosecutor's saying she wants to cover her bases in case there's some change in the law and what a jury has to find or not find for purposes of sentencing. And they have the right to proceed with aggravators. All right, you're right in that if you're found guilty of this charge at this level, you get one sentence. But who knows what a court of appeals would do in the future if aggravators or things weren't presented. I don't know that what would be presented at a sentencing phase from your side or from the state's side, but it sounds like the prosecutor's wanting to cover her bases.
So then I'm not entitled to a hearing before trial starts to find probable cause for these aggravators that were not taken to the grand jury initially?
All right,
We're looping here. We're looping here.
I'm asking.
I'm trying to explain it to you. The jury did find probable cause that this was a dangerous offense. It's included in your indictment. So they did find.
They didn't find these specific aggravators being a dangerous offense, and these specific
aggravators. Can I finish what I said?
Different,
what I was saying?
right?
I didn't interrupt you. Can I finish? Okay. The jury did find probable cause on the dangerous allegation. All right. You're not entitled to a probable cause hearing on the other aggravators.
When is conspiracy to commit murder not a dangerous crime?
When someone says they're going to choke someone to death and they don't actually do it, it's not a dangerous crime.
So,
No dangerous instrument or deadly weapon was used.
so because some instrument may or may not have been used in this crime, it's considered a dangerous crime?
Right.
And these aggravators that talk about something totally different don't have to be found after that it's found a dangerous crime?
Correct.
And that is supported by case law?
Yes.
So that what? When you go to appeal, you can't say it was a non-dangerous crime?
The way that she said case law. That is proud in case law.
Correct.
And that is supported by case law?
Yes.
So that what? When you go to appeal, you can't say it was a non-dangerous crime?
All right. I don't know what to tell you. All right. There was a case that came out about 15 to 20 years ago now called Blakely that said a jury had to determine aggravating factors. Okay, before that, a judge determined aggravating factors at sentencing. Now a jury has to determine it. The reason it's not done in the guilt phase is we don't want the jury to confuse the issues. We want the jury to decide first whether someone's guilty or not guilty, whether the state has proved its burden beyond a reasonable doubt. We don't want them to start thinking about other things like aggravators if they have questions about whether or not the person's even guilty. It tends to confuse the jury and confuse the issues for them. So
Maybe Trina K can just like print her out like the stack of like, the Blakely case solo for her to read. Be like, here you go. Go ahead. Have fun. Read this.
that's why we do the aggravators in a separate hearing. First, you want to make sure the state has proved its burden beyond a reasonable doubt as to your charge.
Is that a content creator? Donut operator. YouTube came up in jury selection. He lives in Texas, I thought. Apparently, no one in court knew who donut operator was. Jury said he believed cops was excused.
But these specific aggravators that they allege, right, the ones that you just went over, you're saying that now after you're found guilty of a dangerous crime, that they're going to go back in, and what is the purpose of that? How does it change anything after that?
I don't know how else to explain it to you.
Read the
So,
case
do you have
law,
other
yes.
issues that you want to bring up today?
Yes, but I would like to finish this first. So are you denying my motion to have a hearing on this?
I'm denying your motion to have a probable cause hearing as to the state's alleged aggravators.
Okay, so you're denying my motion to have a 13.5 hearing on these alleged aggravators
Correct, because
before trial starts?
you're not entitled to one.
Okay,
13.5 says that you're entitled to a probable cause hearing if they amend or change the indictment.
this is not an amendment of the indictment?
It's not. There's a difference
It's an
between,
extension of the indictment. It's not in the indictment.
it's a difference, okay, between an aggravator and changing the charge that you're charged with. Changing the charge that you're charged with is an amendment to the indictment.
The cameraman's like, can I get the fuck out of here? Yeah, she's just not understanding it. The difference between the amendment and then the aggravators. Because again, the judge said that like the amendment would be like if we were changing from conspiracy to commit first degree murder to conspiracy to commit second degree murder, or maybe he said it vice versa, and then you would need a new probable cause, what's it called, a probable cause hearing for that.
For example, if you were just charged with conspiracy to commit first degree murder, all right, but the state didn't allege with the grand jury that it was a dangerous offense, you'd be entitled to a probable cause hearing as to that dangerous allegation because it's changing the charge and it's changing the sentence that you would be getting. These
That's
aggravators,
exactly my point. How after the fact, these aggravators, if they're found, what do they do to change the charge or change the sentence or change anything?
probably nothing in reality. You just said it. They don't change the charge. So you're not entitled to a probable cause hearing.
Yes, use her argument against her.
Okay, then I don't want to have an aggravation phase either.
Well, you can not.
How are you entitled to that? And I'm not entitled to a hearing on probable cause, but you're entitled to have an aggravation phase.
Well, if you don't want to attend, you don't have to attend.
We'll have it without you. That's fine. You don't need to be there.
What else?
He's moving on.
All right. Something dealing with trial is that I've asked several times for headsets for my advisory council. I know that's been an issue that you said we can only have 5 headsets. Is there some way we can do that? Because it's very difficult for them to advise me on things when they kind of don't know what's going on.
If you need a break to consult with your advisory council, we can do that. I can only give so many headsets.
You said you were going to check into that. Is that something that
They
you did
said
check
they-
into and
they
there's no
can't-
more available headsets?
They can't do more than 5 on that particular system or network that they have. I need my court reporter to have one so we can do the sidebars.
Anyone that Lori has wronged in her life ever, I'm so glad that everyone in the world can now see what a real piece of shit she is. Because before, when she had her murder trial, she was like hiding, behind her attorneys, and we didn't really get to hear her speak at all. It wasn't even a live stream, but she didn't even testify. But man, just hearing her like in action, just seeing what a real piece of work she is.
The state's only getting 1. I get 1, so that leaves 2 for you. Whoever you want to have besides yourself, you can choose one of your advisory council or your paralegal.
But you're forcing me to choose between the people that are helping me?
Sure.
Yep, this is how you deal with children. This is how you deal with teenagers. Oh, so you're making me choose? You're making me choose between the people that are helping me? It's like, yeah, I guess so. What's next? I do wonder if they can get headphone splitters, though. Because I wonder if there's only 5 available because they're like plugging 5 into the system. I wonder if you can get a headphone splitter and then you can maybe like split it. But
Okay.
Technically, I don't know I even have to do that. You represent yourself. You're considered your own attorney. You don't even have the right, the right to consult. I shouldn't say that. You have the right to consult with them, but it's not a necessary thing. Because you are acting as your own attorney, you're expected to proceed as your own attorney.
But Judge, I don't know what the fuck I'm doing. I don't know, Lori. Lori, just let them take over. Let them take over. They'll do a better job than you. You just sit there, relax, just chill and just zen out or something. Just zen out. You don't need to represent yourself, ma'am.
To have besides yourself, you can choose one of your advisory council or your paralegal.
But you're forcing me to choose between the people that are helping me?
Sure.
Okay.
Technically, I don't know I even have to do that. You represent yourself. You're considered your own attorney. You don't even have the right, the right to consult. I shouldn't say that. You have the right to consult with them, but it's not a necessary thing. Because you are acting as your own attorney, you're expected to proceed as your own attorney. They don't have an affirmative duty to even give you advice under the case law for being an advisory council. The fact that they do is probably helpful to you. Okay, but you chose to represent yourself. It means you are supposed to act as your own lawyer.
Is it helpful for her, though? I don't know. Is she really taking their advice on anything? Is she even understanding what they're saying? Is she misconstruing things? Oh, I feel bad for these guys. It'll be
You
over
appointed
soon.
them and assigned them to me. I did not ask for them.
Now she's going to put it on the judge. Or you're the one who gave them to me. Okay. Do you not want to use them then? Have they not been helping you?
Appointed them and assigned them to me. I did not ask for them.
Okay, yeah, I did, in case you decided not to represent yourself so they could step in at trial.
Okay, well then is an alternative that we could do sidebars at the bench so that they could be involved during
I
that
think it
time.
depends on the complexity of the question. If it's a simple jury question that, like, for example, can we have a copy of the police report? The answer to that is always no. So I think I'll have to take it on a question by question and issue by issue basis. So if it's an issue where we need everyone at the bench, yes, we can do that.
Hi, Sheena. How are you doing today? Welcome to the shit show. Hello, hello.
But if it's a simple, quick response that we can do with the headsets, we'll do that.
Okay. I have one more issue.
Go
All
ahead.
right. Now what?
Okay. Seeing as how things went in the last trial, my question is, what does the state intend to bring in from Idaho so that I can prepare my questions without being accused by you of opening the door? How can we avoid that when almost every witness has testified in my Idaho trial? And I don't want to be responsible for doing that. So how are we going to handle that?
Well, I will tell the prosecutor to make sure a caution is given to each witness that no matter what the question is, that witness should not think it's a question that would require an answer about prior testimony or prior proceedings. State agrees, right?
It'll just be the same admonitions as last time.
Sure.
I guess they can be further advised that if they think you or the state is asking a question that calls for that sort of answer about prior testimony or a prior proceeding, that maybe we should take a break.
Okay.
Well, I guess my other question is, since she has been convicted of murdering Charles Vallow before this trial, because I know before, for the Charles Vallow trial, she couldn't bring in the her kids, Tammy Daybell. It would have been too prejudicial for her, and it happened after. But I mean, this one could connect, right? It's like, hey, we have someone that, you know, her motive was to get rid of people that was around her. That was her intent. Anyone that was in her way, she was going to get rid of. And that's what happened to Charles Vallow. That's what happened to the kids. But I guess it's maybe still prejudicial and you can't bring that up. That'd be kind of interesting. I'll look into it.
All right. Anything else?
Because I know there's like exceptions to it. Or sorry, am I thinking of... have I looked into Arizona? We looked into... Where's Corey Richards again? Oh, Corey Richards is Utah. We looked into Utah. We looked into Florida. What are some other cases? I don't know if I looked into Arizona, but I was assuming they were just like similar. It's like you can't bring in prior bad acts because it could be too prejudicial. But then there were some instances where you could, and if it went into, if it went towards like, you know, the purpose of it, the intent, the planning, I don't know. I would assume maybe it would be part of one of those categories because she was planning on getting rid of everyone that was in her fucking way. But
That was it.
All right.
Yeah,
We'll see
that's it.
everyone.
I'm in a good mood, Judge. What are you talking about? Why are you all fired up? I'm good. I'm just chilling here.
Prior proceeding that maybe we should take a break.
Okay.
All right. Anything
Yeah, maybe they already had that hearing, 404B hearing for prior bad acts. Yeah, I jumped on this case pretty late, and every time when I open a court document in this case, it's $10 per document. Usually it's either free or maybe they'll charge, I don't know, 15 to 30 cents a page. But oh my fucking God, for fucking Arizona, it's $10 per document. Doesn't matter how many pages it is. It's quite pricey. So I am late into this, so maybe they already had that hearing.
else?
That was it.
All right. We'll see everyone.
She said if both parties can use all the jury for
The footage goes on for a little bit, so I guess we'll just watch for a bit.
the survivors, whatever time tomorrow, since they haven't put out a message yet, or excuse everybody.
Okay. So I'm being informed that the jury commissioner said if the parties stipulate to not bringing in any jurors tomorrow, we can do that. Remember last time, though, we screened whatever number we had. A few of those people didn't show up, even though they were informed they needed to show up. So we have 66. I think because it's a shorter trial, we don't necessarily need 4 alternates, but maybe we should just in case. I don't know.
Judge, I would still want 4, given that we lost
We
2
lost-
in the first 2 days.
We did.
I don't want to waive any appeal issue that it wasn't random for whatever reason. I didn't understand your total reasoning, but how it's saying like the county by county or something, or
No,
section by section?
The theory is that there's
One county. But
maybe certain demographics of people, and I don't know who it is, that wouldn't respond to an email or on.
Good morning, everyone.
Wait, what happened? Okay, sorry. We're just like listening into the wall. Maybe we weren't supposed to be privy to this part of the hearing or something like that, maybe. Okay, so I had some documents that I did download about the judge's ruling, but I don't know if it was from Friday or if it was from a different day. Pre-trial hearing. Let me see really quick. I might have it downloaded. Brandon Boudreaux. Case number.
Respond to an email or online, or they think it's a scam, so they want to show up at the courthouse to do their jury service. Or maybe they don't have access to the internet to begin with. So the theory is that you're missing some sort of group of people that aren't responding remotely and instead would show up at.
Yeah, because you never know, man. The scams are so fucking intricate nowadays.
And so
Sorry. Okay, what do we have? The 30th, that's yesterday, right? Oral argument set and order entered by the court. Let's see, did I download this? Ooh, is it gonna be another $10 for this? Let me see, what do I have? Lori Vallow. No, my most recent document that I have is from the 25th. Oh, gosh, okay. Let me look at the preview. Let's see. Thanks for letting me know, by the way. Appreciate it. The court has received the defendant's motion to disqualify judge. It is ordered treating the defendant's motion as a motion for a change of judge. It's further ordered deferring the judge's motion to Judge Green for ruling, which that has already been done. Why does this come in so late, though? Oh, just like minute entry. Okay. Basically, I think just summarizing what happened. Yeah, so she wanted to have the judge disqualified, and she didn't want this judge to be on it. So they had a different judge assigned to it, and the judge denied it on the spot. So Judge Boreski is still here. However, I did, let's see, what did I not? Lori Vallow respects that this court denies the state's motion limiting to preclude inadmissible evidence relating to, I haven't read this yet. Do you guys want me to read it to you? There's some new court documents that are here. Something about a witness, Tammy Latchkick. I don't know how to pronounce it. Lachcik. How do you pronounce that? There was this that was in there, and then what is this? Oh, is this the same thing? No! What is this? Oh no, did I get it mixed up? The court will address the issue. Oh yeah, and then the court made, okay. So I have two new pages, and then read it. Okay, I'll read it. I will read it to you guys. I'm not hungry yet. We're good. Got some time. How are you guys doing, by the way? How's everyone doing on this beautiful Saturday? I was going to do some yard work and spread some compost and some manure on my yard, but it is freaking hot in LA right now. See, you like that? I didn't cuss the time. Yeah, it's really hot in LA right now. Oh, gosh, I hate it. I hate it. Yesterday was really hot too. I came outside at 5 p.m. to walk Shira, and I was like, whoa, what the? It was so hot. All right, let's read the court's, we'll read this one first. This is the minute entry. Okay. Defendant's motion for a new trial filed May 1st, 2025. State's response to defendant's motion for a new trial filed May 6th, 2025. Defendant's reply to state's response to defendant's motion for a new trial filed May 14, 2025. It is already the end of May. Time is going by so crazy. I know I was going to do it in the morning, but I had a lot of stuff to do in the morning. And I was working out too. Because now it's like, well, if it's going to get really hot, I have to work out when it's not hot, and I have to do the garden stuff when it's not hot. We're all just fighting for, cold times here. Oh, Indiana. Nice. It's only 58 degrees and windy here in PA. Oh, I don't know about the wind. All right. The court will address the issues in an order in which they appear in the defendant's motion. Juror misconduct here. I will zoom in for you guys. The defendant alleges there was juror misconduct based on the statement Juror 15 made to reporters following the verdict, wherein he stated, I feel sorry for her. Driving home yesterday, I was like, God, she's spending the next 3 lives in prison, in a cell. Don't feel bad for her. On its face, the statement could seem to indicate the juror violated the admonition and researched the defendant, acquiring knowledge about her sentence imposed in another matter prior to the lifting of the admonition. However, the state's response included multiple additional media clips of statement Juror 15 made, both immediately prior to and after the statement referenced herein above, and every one of which he specifically denies any knowledge of the defendant's other case / prior sentence prior to the court releasing the jurors from the admonition. At best, Juror 15 gave a single statement which seems to be in conflict with all of his other statements when he specifically denied any misconduct. Here in the limited record of the pleadings before the court, there is no affidavits or sworn testimony evidencing any misconduct as contemplated by Rule 24(1)(d) to the second power. I've never seen that before. Oh, hold on a second. Oh, that's just a footnote. It's like, to the second power. The court does not find a clear indication of juror misconduct, let alone any evidence of prejudice to the defendant. Hey, Gloria, how are you doing today? First time here. Hi, Gloria. How's it going? Happy Saturday or maybe Sunday, depending on where in the world you are. But hello, hello. Juror misconduct requires a new trial only if the defendant shows actual prejudice or if it can fairly be presumed from facts. State v. Lair. B. Preclusion of Tylee Ryan, Alex Cox statements, and impermissible testimony by Detective Daniel Coons. So when we were watching the trial, we were wondering why the body cam, some portions of it were muted, and the part that was muted was when Tylee was speaking, Lori was around, and we didn't get to see any interviews from Tylee Ryan and from Alex Cox as well. It is because they are both deceased. The court issued a preliminary pretrial ruling on March 11, 2025 regarding the inadmissibility of statements made by Tylee Ryan and Alex Cox. Again, Tylee was her daughter at the time, 16, 17 years old. Alex Cox is her brother, the one that she commissioned to murder people. Murder her family, specifically. The court's ruling stated that out-of-court statements made by Tylee and Alex appear to be hearsay, and the defendant failed to establish that any specific statement was either non-hearsay or fell within the exception to the rule, including hearsay. The court went on to give the defendant the opportunity to offer specific statements at trial by stating that the defendant could re-urge the issue outside the presence of the jury. Not only, and again, this is a very reoccurring theme with Lori Vallow, the judge will make a ruling. However, sometimes he'll leave it open later on, like, hey, if you want to continue arguing it, you're feel free to do so. If you want to do X, Y, and Z, feel free to do it. Lori just doesn't do it. I don't know if it's because she forgets, or she doesn't know what she's doing, or she doesn't know how to argue it. I don't know. She's a hot mess. Like I said, Lori, just get a public defender to do this for you. Not only did the defendant never take up the court up on its offer during trial, the defendant's motion for a new trial in reply only argues in generalities. Yeah, that's a common theme with Lori. Failing to set forth any specific statements that should have been admitted to evidence either under non-hearsay exemption or an exception to the hearsay rule. It's because, when Lori is arguing and she gets into the generalities of it, it's because she doesn't know what she's arguing and she probably doesn't know how to argue it. I don't know. There's just so much that an advisory council can do for her. As to Detective Coons' testimony, yeah, guys, thank you so much for being so welcoming. I do appreciate it. Thank you. It's nice in PA right now, 52, and you're a part of PA. Oh, we got more people in PA. You want her niece to testify? She's so complicit. I don't think she's on the witness list. I didn't see her name on there. Yeah, no Melanie. I think Melanie has a new last name now. As to Detective Coons' testimony, the defendant argues the detective did not have foundation to testify as an expert. Sufficient foundation was laid for the detective to give his opinion, and the defendant offered no specific information, surprise, surprise, as to what additional foundation should have been required, or not surprise. To the extent the defendant believes the witness was not qualified or his opinion should not be given weight by the jury, she had the opportunity to cross-examine the witness about his qualifications, or lack of, as well as the basis for his opinion. Yep, and she didn't do it. All right, 1. Even if there was misconduct, the defendant's own motion undercuts her argument that prejudice exists because she pointed out Juror 15 stated he was leaning toward not guilty through deliberations, a distinct indication that if Juror 15 did have any extraneous information at the time, it did not affect his consideration of the evidence. Number 2, neither the state nor the defense chose to have an affidavit prepared by Juror 15 or any other juror, so the court is left with the media clips provided in the pleadings. The defendant, Lori Vallow, also argues she did not have time to rebut Detective Coons' testimony. The record is clear that the defendant was offered more time to prepare for trial and declined. Moreover, the argument that the basis of Detective Coons' testimony was a walkthrough of Alex Cox is not supported by the record. The defendant's reply, for the first time, raises the additional argument that Tylee Ryan's statements also formed the basis for Detective Coons' testimony. Again, there's no evidence of this. The defendant offered no specific statement by Tylee Ryan or Alex Cox to support her assertion. And even if what Alex Cox and or Tylee Ryan told Detective Coons somehow contributed to his opinion, the defendant never asked the detective those questions, i.e., did anything Alex Cox show you or tell you to contribute to your opinion? She never asked that. This type of question would have been permissible. However, the defendant did not ask, nor was she ever precluded from asking it. because she doesn't know what she's doing. You know, doesn't know what she's doing. She goes up there, you know, she's trying to dress all laurely like, but the skills don't match. The skills don't match the outfit. The court finds the statement of Tylee Ryan and Alex Cox were properly excluded, and the defendant has failed to raise a single specific statement that should have permissibly allowed under the rules of evidence. Nor does the defendant establish Detective Kuhn's testimony was improper. Hey, Christine, happy Saturday. How are you? Hello. All right, next one. C, discovery violation. Oh, this part was pretty funny. This is when the court ended and the jury was sent out. And do you remember how the state was trying to sort of help Lori Vallow's expert or advisory counsel? I don't know who it was, but there was a file that they were trying to open. They couldn't open it. And then the state was like, per my last email, Energy, this is how you do it. This is how you don't do it. And X, Y, and Z. This is your job. Figure it out. So this is when they were trying to figure out how to open the files for like Charles Vallow's phone or something. All right, discovery violation. Although Lori's motion alleges the contents of the hard drive are exculpatory, she never articulates any single item whatsoever that would constitute exculpatory evidence. Again, merely stating something is exculpatory does not make it so. You know, Lori strikes me as a person who doesn't really back up her arguments with any evidence. And she probably does this by steamrolling over people with her charm, with her looks maybe. And honestly, I think she's the type of person who's like, it is this way because I say so. I don't need to back it up. It's just the way it is. The defendant's request for additional discovery related to Charles Vallow's phone was accommodated. The state had previously disclosed all evidence it had in its possession at the time. The defendant requested access to the actual phone to run a new examination with software that has been updated since the phone was examined several years ago. The defense has offered no evidence that any additional information was obtained from the phone, let alone it being exculpatory. And my understanding is that the state argued Lori Vallow actually had this information for, I don't know, more than over a year. Court finds no discovery violation. D, prosecutorial misconduct. Oh, yeah, she was not happy with the statements that Trina K was making. I think it was one about Lori fake crying, essentially, and opening arguments. And maybe the nonchalantness. The court finds nothing in the defendant's allegations come close to establishing prosecutorial misconduct. The state is allowed to argue reasonable inferences from the evidence presented. The defense does not have to agree with those inferences and is permitted to argue that evidence should be interpreted differently. Lori is like, yeah, because I don't agree with it. It's just, for example, the judge not granting her motions. She's like, well, it's not because you're not legally sound. It's because you're just biased against me. You're prejudiced against me. Defendant argues in her reply for the first time that both the state and the court violated the defendant's rights under the Religious Freedom Restoration Act. Although new arguments are not to be considered when first raised in a reply, the court will nonetheless address this. He's like, yeah, I'll just fucking entertain it. Why the fuck not? The RFRA protects religious freedom and prohibits the government from substantially burdening a person's exercise of religion. There is no conduct, but either the state or court that somehow infringed upon the defendant's freedom to practice her religion. Nor is there anything about the trial that impacts the defendant's freedom to believe whatever it is that she chooses to believe. I like that sentence. Whatever it is that she chooses to believe, zombies, I don't fucking know, whatever shit show she wants to get into. Moreover, the RFRA does not protect someone from committing criminal acts in the name of religion, nor does the RFRA prevent any person from disagreeing with another's belief system. Here, different witnesses may have different interpretations regarding who Nephi was or the significance of his story. The defendant had an opportunity to cross-examine those witnesses regarding the same. None of this infringes on the defendant's religious freedom. Now, unfortunately for Lori, when she was cross-examining, she did not come off as very effective, in my opinion, because she was very emotionally charged and she just seemed like someone that was just very fucking unhinged. For these reasons, the court finds no prosecutorial misconduct. E, court's lack of impartiality. The defendant alleges the court was not impartial because the court struck two defendant's witnesses from the defendant witness list. Now, we watched the part of the hearing where they addressed this because she wanted to call Nate Eaton as one of the witnesses. And I think the other one was Brandon Boudreaux. And then I remember maybe another person as well. The court tried asking her what kind of testimony that she was going to get out of them or something like that, and she couldn't really answer the question. And then I think, like, in regards to one of the witnesses, the judge was like, okay, well, if you want to call this witness later on, you can bring it up later. And then she ends up not doing that anyways. Gloria says, I cannot wait for this trial to be over. She just goes away forever. Yeah, we didn't realize just how unbearable she was. I liked it better when she had attorneys representing her and she just, just shut the fuck up. Does anyone else say nonchalant enchilada every time they hear someone say the word nonchalant? Me. All right. Defendant alleges the court was not impartial because the court struck to the witnesses. Contrary to the defendant's assertion that no rule of law or evidence requires her to establish a witness has relevant information. That's right. He was asking about relevant information. Yes. And she's like, they have relevant information. I don't know what to tell you. I don't want to divulge my entire defense to you guys. Do I have to do that? And he's like, yeah, you kind of do. You kind of have to tell us what the fuck's going on. All right, so he talks about Arizona Rules of Evidence 601, 602 requires just that. Prior to trial, the defendant was given an opportunity to make a general offer of proof as to what relevant information the witnesses provide, which the defendant was unable to provide. She had nothing to say. She couldn't argue it. When the court precluded the witnesses, the defendant was also advised by the court that during the course of the trial, if she believed these witnesses had relevant information, the court would revisit the issue. Thereafter, the defendant did not offer any witness, even though she was specifically told she could re-urge the issue. In addition, in her motion for a new trial, the defendant offers no further information on what testimony the witnesses would have given if they were permitted to be called as witnesses. It's because, Judge, she doesn't know the answer to the question. She doesn't fucking know. She just wants to wing it. The defendant also argues the court demonstrated a bias. This is so funny. Okay, so this is when the judge made the comment saying, well, I guess to the extent you're comparing yourself to the religious person or whatever, I guess I'll allow the question. The defendant also argues the court demonstrated a bias based on the court's comment made while overruling the state's objection during the defendant's questioning of Serena Sharp. Poor Serena. I think Serena had it the worst during cross-examination. Serena seems like a really sweet woman, and I think she was just like, why am I here? Lori's unhinged. Oh my God, get me off the damn stand. Some minimal relevance based on the context of the defendant's line of questioning. The court notes the defendant's argument as to why the question was relevant was not in line with why the court surmised it was relevant. While the court's comment was not necessary, okay, he's admitting that, it is not evidence bias, nor does it mean the court was demonstrating any partiality. Nonetheless, the court acknowledges the comment was unnecessary, and again, that's something that he will admit. Will Lori ever admit to her mistakes? No, never. The court should have simply overruled the state's objection without comment. Moreover, the court has been presented no evidence whatsoever that this comment influenced the jurors. I thought it was just so funny. All right, so denying the defendant's motion for a new trial filed May 1st, 2025. That's one. Okay, so I want to know more about Tammy Latchchick. If you guys know who this person is, let me know. Okay, so Lori wants the court to deny the state's motion in limine to preclude inadmissible evidence relating to Tammy Latchchick. The information of incidents dated December 30th, 2024 through March 6th, 2025 of the former, forensic technician, Tammy, is information that is relevant to the witness's mental state, credibility, inaccuracy, probabilities, and any probative value that would be outweighed by unfair prejudice. Okay, so this is Lori's motion, y'all. We're reading Lori's motion. All right, let's just read a little bit of it because I am nosy. I'm very curious. Facts, law, and argument. The state's former expert, Tammy, in credibility is crucial to the case. Gilbert Police Department Inter-Office Memo from Chief Michael Solberg, dated March 6, 2025. Oh, that's this year. Gilbert Police Department General Order, that's a lot of a mouthful. Refuses to provide truthful names check under Tammy Stoltz, her maiden name. Okay. The Gilbert Police Department General Order, more mouthfuls. Their failure to participate in or giving false or misleading statements or misrepresenting or omitting material information to a supervisor or other people in the position or other person in a position of authority in connection with any investigation or the reporting of any department-related business. Okay, where are we going here? Paragraph 5, the recommendation of dismissal of FSS Tammy from employment with the Gilbert Police Department. If she had not resigned, she would have been terminated. All right. Ms. Tammy's former employer investigated her ethics and credibility in the above facts, providing false, misleading statements, misrepresenting and omitting material information, especially for the purpose of investigating. Detective knowingly made false report entries with the intent to impede, obstruct, or influence investigation. I mean, this is coming from Lori. It's hard to take her word for anything. because Lori just has a really good job. You know, she does a really good job at just like misconstruing things or just completely just like destroying the truth and just bullshitting. I think it's just the best way to say it. Just bullshitting. All right, so someone says Tammy is CSI. She was in a hotel room, really drunk 4 years later. I don't think it affects her collection of evidence in 2019. Oh, I see. Hi, Jen. How are you doing today? Oh, cute emote. Matches your username. Hello, hello. All right, so suppression of evidence and inference of innocence. Tammy was at the time of the incident an officer and member of the Gilbert Police Department. Her alcohol content is 0.157. Damn. After allegedly 8 hours of less consumption of alcohol. Okay. In her interview, recollection of event, she struggles with memory loss during questioning or investigation. All right. She states that when she was mentally, as far as having a mental breakdown with alcohol and isolation. Sorry, where's the date? Do we have dates for this? I don't see any dates. Her son stated she gets really, really, really drunk. It's been going on for years. 2 750 milliliter liquor bottles and about 10 shooters. Jesus, I hope she's gotten help. That's a lot of alcohol. Wow. All right, October 9th, 2019, she photographed and possessed DNA swabs and the gunshot residue kits in Rexburg, Idaho's impound lot. As the above facts from an internal investigation to Miss Tammy state, the expert's credibility is tainted. So she's saying that like she has a history of alcohol abuse and therefore she could not be trusted with collecting alcohol. What if she's drunk on the job? Stuff like that, I guess. Her long history of alcohol abuse and self-isolation in hotels raises the issue that Miss Tammy may have been under the influence. She lacked hygiene care and has been coping with alcohol to cope with her mental state of mind. The inaccuracy probabilities across contamination of evidence are high given the years of alcohol abuse and which affected her memory. Jesus. I guess I could see why the state wanted to have this under seal. Or just like putting her shit out there. But I guess was she also, I don't know, showing signs of being drunk on the job or something like that when she was collecting evidence for the Lori Vallow trial? I don't know if it's going to get there. State lacks evidence and truthful expert testimony. Tammy is an alleged witness. Prior cases Tammy was involved can be reopened based on the above. Oh, what's this? Tammy's forensic processing of the alleged crime scene is crucial for the breach of probable contamination, which addresses why the state is using Tammy, who is forced to resign due to similar offense based on character and credibility, as the state is implying on the defendant. Okay. All right. This basically just. Oh wow. What is this? Who wrote this? Did Lori write this? I don't know. I feel like we're just dropping a lot of tea on someone that might not be, could be important, might not be important. This is the investigation submitted by Jason Biggs at Gilbert Police Department. But I mean, you said it was in 2024, right? Yeah, 2024. Okay, I'm not going to read this because this happened like 5 years after Lori Vallow's incident. Okay. Let me read the other. Oh no, they locked me out. How dare you? I'm not done yet. Go back in. Let's read the one that came out yesterday. I'll pay $10 for it. We'll see if it's anything. Case detail. All right. Just in case. I did look at the preview, but I kind of wanted to see the whole thing. Now, what I do like about this, though, when you do check out, they make it really easy to check out on here. Oh, sorry. Let's go back up here. Lori. How did she find out about this? Who alerted her about this? Okay, I'll leave it on the screen. Let me check out really quick. Check out, please. I think my credit card's on file. Make it easy. All right. Let's download this document. What are you guys up to today? Do you guys have any plans for the weekend? Are y'all doing anything? Got anything special going on? Cases. We have a birthday party to go to. Oh my god, I haven't eaten lunch yet. I gotta eat lunch soon too. Lori Vallow. Lori. We did a stream a couple days ago about the Alexi Treviso case. It will go out today, I think. I think it's all done. I just haven't pushed it out yet. 31. Okay. Let's read this. Oh no! No! Ah! I thought there was more pages. Is there not a way for me to tell if there's more pages or not? Oh my god, I got scammed. Okay, I got scammed. This was basically shown on the preview, and I was like, maybe there's more. $10 for this shit. Well, if it's $10, I'm gonna read it, okay? Minute entry. Complex case. Lori N. Daybell. Hashtag G as in girl 062213. The court is in receipt of defendant's motion to disqualify judge filed May 25th, 2025. And the state's response to defendant's motion to disqualify judge filed May 26th, 2025. I'm so sad. It is ordered treating the defendant's motion as a motion for a change of judge. It is further ordered deferring the defendant's motion to Judge Green for ruling. Okay, we already do this. Oh, yeah. Hey, Carolina, it's been a while. How are you? Hi. You have a baby shower tomorrow? Oh, so excited to be auntie. Fun, exciting. Have fun. Have fun doing all the baby shower games. Oh, my God. Sometimes those games are freaking wild, okay? There's one where you put brown stuff in the diaper and then you smell it to try to figure out what the smell is. Usually it's things that don't smell bad, but it's like chocolate and stuff like that. But like, oh gosh, the visual of it. Ugh, I can't. You're sewing. I want to learn how to sew. I wanted to get a sewing, what do you call it? A sewing kit? I don't know what it's called. It's a sewing machine. Oh yeah, sewing machine. Because I wanted to learn how to sew. I want to learn how to make blinds, dude, because blinds are so expensive. Why are curtains so damn expensive? It's ridiculous. As an aunt, you have a duty to be loud and obnoxious. To buy loud and obnoxious toys. We always do that. But it's because I buy the toys that look fun, and then it's on the damn list. But it's like drum set, the piano thing. It just looks like fun stuff to do, you know? Alrighty, guys. Well, that's it for today. I'm so sorry that we wasted 10 on this. Nothing really happened here. So we have the judge's order on Lori's motion to be dismissed. Is that the word I'm looking for? Motion dismissed? Yeah, I guess so. It sounded weird when I said it out loud for some reason. So that's it. That's it for Lori Vallow. We'll see if she will be better by Monday. She has to quarantine because she, I guess, was not feeling well yesterday afternoon. And we'll hopefully continue with jury selection. And then maybe we'll do opening statements on Monday or Tuesday. I'll keep an eye out for it. So we will be streaming the trial. And yeah, it'll be a short one though. At least it's not like a 6-week fucking trial or anything like that. It'll be maybe like 7 to 10 days. Maybe Lori will change her mind and we'll actually do more cross-examination, and maybe she'll change her mind and actually call witnesses this time. But yeah. Oh no! You're recuperating from a horrible week. House fire where I live? Oh gosh, sounds horrible. Like the whole house just caught on fire? What? Did they know the cause of it? They're so expensive because it's expensive to weave fabrics that wide. Many fabric stores have sewing classes. Oh, that sounds interesting. The baby girl clothes are so sweet. I could buy them all, I swear. I know baby clothes are so adorable. Baby shoes are adorable. But man, kids, they grow out of it so quickly. Have a good weekend. Yeah, you guys have a good one. Mama Bear, I'm so sorry to hear that. That's so sad. That's so incredibly sad and tragic. Carolina, I know it's been a while. Sorry, I missed your lives. It's all good. Going back to watch and replay. Yeah, Laura's pretty unhinged today, so get ready. You might need some chamomile tea or maybe like a shot or something after dealing with her. But I will see you guys next week. All right, enjoy the rest of your weekend. Try to enjoy the rest of your weekend. Go outside, get some fresh air. You know, hug your bubbas, your loved ones, your pups and your cats and all your animals and stuff like that. And I will see you guys next week. Yeah, it's being investigated. The whole house. Jesus. That's so crazy. Oh, thanks, Lauren. I appreciate it. All right, guys. Take care. Have a good weekend. Visenya, Sarah, Jen, thanks for popping in. Fire, thank you so much for the bit. I don't know if Moondog and Nacho's still here. You guys have a good weekend, all right? Take care, y'all. Have a good one. We'll have a new video for Alexa Treviso. I think it'll be out like after the stream. I think it's done.